on the motions and testimony how they've been harmed.
Right.
That is how you prove that.
Yeah.
Okay. Now let's assume that you win the verdict and they challenge it and they lose on their challenges and the money's coming. Does the person that you represent now have to pay a portion of the money that they got to you, or can you get attorney's fees and costs from the employer if you prevail?
Well, yes and yes. Civil rights cases carry with them, if you're successful in trial, they carry with them the award of a reasonable attorney's fee. In our district, the federal district, it's about $180 an hour is the accepted fee rate. So what happens there is that I will charge somebody a third of what we get less any court-awarded attorney's fee. So let's say we go to trial and get $9,000 in damages. I got $3,000 covered. But if they award me a $2,500 attorney's fee, then I've got $500 covered.
Well, I've seen cases where the attorney's fees far exceeded the actual damages paid to the plaintiff. Is that uncommon, or is that a common situation?
It's not as common as I wish it was. But yes, that will happen. And all you have to do is establish damages of $1. You just have to win something, and the successful attorney is entitled to an attorney's fee.
Now, what? Let's say somebody just really, really loved their job, and they really want their job back.
Mm-hmm.
Is reinstatement a possible remedy that's available to an employee who's been wrongfully terminated?
No, it isn't. And what I tell clients is that the legal system, the language the legal system speaks is money damages. So I have had cases, very, very few, literally I think maybe 2 or 3, where during the settlement process, the person really wanted to go back to work and the employer really wanted them to go back to work, and that employee goes back to work. And so that cuts off the damages. But most often, again, remember we talked about how high feelings tend to run in these cases. And the court can't order it, cannot, under any circumstance, say, I'm putting you back to work.
So you can't make somebody work. That's called slavery, and you can't make somebody hire somebody to work for them if they don't want
Exactly.
it to happen.
Involuntary servitude.
Is that
Exactly.
the long and the short of it?
Mm-hmm.
Now,
Exactly.
what is the success rate generally in this kind of litigation? Assuming you actually agree to represent somebody,
Mm-hmm.
how successful generally are you? Like, is it a 50-50 deal and 60-40? Like, for example, I've heard that in medical malpractice cases in Oklahoma, the doctors win more than 90% of the cases that are filed against them. Is that also true in these employment cases? Are they hard cases to make generally?
Generally, they're certainly not as hard as malpractice cases. And juries in this neck of the woods are employer friendly. There's no doubt about that. They're conservative, and they can have the idea that well, if you're really as good as you were saying, I don't understand how you got fired. So they can be a little bit callous. But I take cases where every lawsuit's 2 parts: liability and damages. Liability is did somebody do something wrong to somebody, legally wrong? And if so, damages is what are the financial consequences of that? I take cases where there's liability, and I don't worry about the damages. If I see a case that I believe I can take to a jury and win based on liability, then I'm going to take that case, and I'm just going to hope for the best on the damages. So that approach, I'm pretty experienced at figuring out what's going to happen, what a judge is going to do with a case and what a jury is going to do with the case. So my personal experience is I've certainly won more cases than I've lost.
Now, I assume you say jurors in this neck of the woods are conservative. I assume the judges are conservative too, correct?
Yeah.
And
Yeah, they are. And the appeals court for federal courts in our district is in Denver, the 10th Circuit Court of Appeals. And they are one of the more conservative, employer friendly. You get like the Fifth Circuit down in Louisiana, they never met an employee they didn't like. And up in the Northeast, the appeals courts tend to be more employee friendly. The middle of the country, they tend to be more employer friendly. Really, just kind of like the political map,
Right.
the presidential election.
Is there anything else about this particular area of the law that you would really like to tell people who might run into that view this video that we haven't already discussed? It's sort of a catch-all question.
Sure.
Is there anything else you'd like to tell them about this area of the law in terms of what makes a case attractive to you or unattractive, that sort of thing, so they'll know whether you might be interested in representing them if they were to call you?
Well, what I like to do is again, my website, TulsaEmploymentLawyer.com. I've got on there, I've got the form that you have to file with the EEOC. If you plan to pursue a case, then you must file with the Equal Employment Opportunity Commission within 180 days of the act of discrimination.
So if you get now wait a minute, your act of discrimination, is that getting fired or is it some other event?
Well, it can be either. I mean, if you're dealing with wrongful termination, it's the time you're fired. If you're dealing with failure to promote, it's from the time you didn't get the promotion. If you're dealing with unequal wages, then it is based on when your last pay period was. When you began to be discriminated against in terms of your wages based on your race or gender.
It seems pretty short. It is.
Yeah, it is. And it doesn't make any sense at all. You know, you look at statute of limitations on written contracts is 5 years, and on personal injury is 2 years, and on a case as important as employment, it's 180 days. You go, well, where'd that come from? You know, what is 6 months? That's an incredibly short time period.
Now, do people who think they've been discriminated against, they have to file an EEOC complaint as a predicate to filing the lawsuit in federal court?
Mandatory, absolutely. And the website, the forms are on my website, TulsaEmploymentLawyer.com. You just download it, fill out the complaint form. If you're having a problem with some of the language, my email address is on there, jeff.nix@morelaw.com.
They just want to pick up the phone and call you. What's your local telephone number?
They don't want to call me on my cell phone. My law office number, 918-587-3193.
Well, thank you for taking the time to talk to us today, and we look forward to speaking with you in the future on other subjects relating to employment law.
Well, it's my pleasure. Thanks a lot.
Thank you. Have a great day.